Welcome to SCOTUScast, a project of the Federalist Society for Law and Public Policy Studies. Our contributors join us from around the country to bring you expert commentary on U.S. Supreme Court cases as they are argued and decisions are issued. The Federalist Society takes no position on particular legal or public policy issues. All expressions of opinion are those of the speaker.
On June 29, 2020, the Supreme Court issued its first major abortion decision on the merits since Justice Anthony Kennedy's retirement. The consolidated cases, June Medical Services v. Russo and Russo v. June Medical Services, involve the constitutionality of Louisiana's law requiring physicians who perform abortions to have admitting privileges at a local hospital, and whether abortion providers can be presumed to have third-party standing to challenge health and safety regulations, such as Louisiana's admitting privileges law on behalf of their patients. The plurality opinion held that the abortion providers had standing and Louisiana's law was unconstitutional because it imposed an undue burden. And now, to discuss the case, we have Stephen H. Aden, Chief Legal Officer and General Counsel at Americans United for Life.
Well, the Supreme Court delivered the promised fireworks this morning in June Medical Services versus Russo, sending out what I think is a 4-1-4 decision, 4 in the plurality with the Chief Justice concurring in the judgment and 4 in dissent. Justice Stephen Breyer wrote for the plurality, as he did for the court in the Hellerstedt decision 4 years ago, and by all accounts, it seemed to be Hellerstedt redux, both for the 4 justices in the plurality this time, as well as for the Chief Justice, although for separate reasons that I'll get to in a little bit. I found Justice Breyer's opinion for the plurality to be like paint by numbers. It was remarkably similar to his opinion for the court in Hellerstedt. He reviewed the rulings of the Fifth Circuit, the Louisiana reasons for crafting the statute, both asserted and what he thought they were. He looked at the standing issue dismissively, actually starting there. And first he said it is waived because Louisiana did not raise it until they got to the Supreme Court, and because the plurality regarded this kind of third-party justiciary standing as prudential rather than a matter of Article III jurisprudence, an Article III requirement, a constitutional requirement. He said it could be waived, and it wasn't. It was waived because they didn't raise it until they got to the Supreme Court. And then kind of in a, you're ugly and your mother dresses you funny opinion, he said, and by the way, if you hadn't waived it, we'd have said the same thing. And he gave a half-page string cite to the Supreme Court cases that he said had given abortion providers third-party standing to plead on behalf of the patients that have abortions going back, in fact, all the way to the mid-'70s. And he said, it's an established principle that the appropriate challenger to a statute is the party upon whom the challenge statute imposes legal duties and disabilities. And that, in this case, that party is the abortion provider. He called June Medical Services, Hope Clinic, the obvious claimant. And then Justice Breyer focused the merits analysis, I would say, on the question whether Act 620 in Louisiana would foreclose abortion functionally in the whole state of Louisiana, as the district court in Baton Rouge had said it would. And Justice Breyer and the plurality did a pretty thoroughgoing review of the evidence, albeit, from their point of view. And he went into some detail on the John Doe abortion providers and the reasons why they could not secure admitting privileges, even though they had 18 months to do so under the modified temporary restraining order that Judge Diggerfeld had imposed. He said, we know how this works. We know that hospitals don't like abortion providers. We know that frequently they require those applying for admitting privileges to have case examples of patients they have actually admitted to the hospital employing privileges or in the past, and abortion is so safe that that's difficult to do. And he said that there were many, there were several other administrative obstacles, procedural obstacles that explained why the abortionists in this case were unable to, by and large, secure the requisite admitting privileges. And then, again, in a workmanlike way, he goes on to explain how, in his view, that would close most of the abortion provision in the state of Louisiana. It would close two of the remaining three clinics and then shut down probably half the operation of the third, and the abortionists there could not pick up the gap there and provide the residual demand. So all in all, very much like his opinion for the court in Hellerstedt. And the bottom line was, he said, we review the district court's findings for clear error. And the plurality did not find clear error in the district court's findings that the admitting privileges requirement does not protect women's health and provides no significant health benefits and makes no improvement to women's health compared to prior law. And on that basis, he says it is unconstitutional. And then the Chief Justice filed a concurring opinion, concurring in the judgment, which was somewhat curious for several reasons. First, because he started by acknowledging that he dissented in Hellerstedt 4 years ago, and he's very upfront that he continues to believe that Hellerstedt was, quote unquote, wrongly decided. I joined the dissent in Hellerstedt. I continue to believe the case was wrongly decided. But then he says the question today is not whether Hellerstedt was right or wrong, but whether to adhere to it in deciding the present case. And then he spills much ink about stare decisis. And for those who watch the court for this particular doctrine, this case, this opinion in particular, I think will be a real bellwether because he's very clear that wrongfulness is not enough. He doesn't take Justice Clarence Thomas's view that if you get a constitutional rule wrong, it ought to be overturned. And he reiterated what he had said before, which is that stare decisis, absent special circumstances, requires the court to treat two cases alike. He said this promotes even-handed, predictable, and consistent development of legal principles. It fosters reliance on judicial decisions. And for all those reasons, the court needs to be predictable. And that is why he said in this case, because he cannot distinguish either the language of the Texas and Louisiana statutes nor their effect on abortion provision in those states, he felt bound by the ultimate holding in Hellerstedt. Although he felt bound by the ultimate holding in Hellerstedt, he went on at length to explain why he had a different view of what Hellerstedt required. Now, recall that the Chief Justice, along with the four in the plurality, all said that Hellerstedt was an expression of the undue burden standard of Planned Parenthood versus Casey. Hellerstedt doesn't stand alone. It's articulating an established rule standard for review that the court articulated in Planned Parenthood versus Casey. But the Chief Justice in this case said that the plurality was incorrect. He reads Casey through the lens of Hellerstedt to be not a balancing test as the plurality does, not a straight up balance the benefits with the burdens rather. But he says that Casey was a two-step analysis, and this is potentially key for down the road. First of all, he said that the threshold requirement is that the state show it have a legitimate purpose and that the law be reasonably related to that goal. So in other words, it's almost a rational basis test. If the legislature was promulgating a legitimate rule, in other words, in this case, a legitimate medical standard, and there are decent reasons for it, good reasons for it, reasonably related to between a reasonable relation between the ends and the means, that's fine. And then you move on from there. You show deference to the legislature, as the court said in Gonzalez versus Carhart. You show deference to the legislature, and then you move to the second part of the Casey analysis, which is whether the law has an effect of placing a substantial obstacle in the path of a woman seeking an abortion. And so on that basis, he said that he had to concur with the plurality, that in this case, the Louisiana situation was not distinguishable from the Texas situation, that there was too much access to abortion foreclosed, and that consequently he felt bound by the holding in Hallerstedt. And there are a couple of interesting side notes with Chief Justice Roberts' opinion, concurring opinion. One was the matter of standing. He only addresses the standing argument in a very brief footnote, and he simply says, for the reasons the plurality explains, he says they have standing. All four members of the dissent questioned whether abortion providers generally, or abortion providers in this instance in Louisiana, ought to be heard in court pleading the rights of the women that come to them. But the Chief Justice passed over that, merely saying, I got you. I agree with the plurality, and I leave it to you, in essence, to figure out why I agree with the plurality, because he wasn't explaining. And then you had four justices writing dissents. Justice Brett Kavanaugh wrote a very brief dissent, only a paragraph or two, in which he said essentially that we didn't have enough facts, and he would like the court to send the case back down to determine what the true facts were. You can take that as you like. The case went through the district court and up through the Fifth Circuit twice, and some very able lawyers, not myself included, believe me, but some very fine trial lawyers, and the solicitor of Louisiana said that there was plenty of evidence, and I don't think anybody disagreed with that up to the second go-round in the Supreme Court. And then Justice Thomas filed the lead dissenting opinion. Justice Thomas wrote for himself, and he made some of the points that have become familiar to us who have read Justice Thomas' opinions in abortion cases. He said the court lacked jurisdiction to hear the case on standing grounds, even if there was standing. Louisiana's law was a proper assertion of police powers, and that Roe and its progeny is a terrific mess that ought to be reversed. And he doubled down is the wrong term. He tripled or quadrupled down on the ongoing debate he's having with the Chief Justice over whether stare decisis requires adherence to wrongly decided precedents or whether it requires special circumstances to overturn them. There was another dissent written by Justice Samuel Alito. He was joined by Justice Gorsuch in the entirety, and by Justice Thomas for the most part, except for his call to remand, and by Justice Kavanaugh for the most part. Anyone who is a favor of Justice Alito's, is a fan of Justice Alito's, as I am, will remember that he had an eloquent and very clever dissent in Hallerstedt. Well, you'll get more of the same here. He calls the plurality out. He calls the Chief Justice out. There's really an air, a flavor of real disappointment, personal disappointment with the Chief Justice in Justice Alito's dissent and in Justice Thomas's dissent. I think that they feel that the Chief Justice was kind of twisting himself into knots to come up with some of the positions that he does in this case, and to perpetuate what they regard as an intractable Procrustean bed, to borrow a term from the late Justice Scalia. I think they're right. Wrapping up, Justice Gorsuch had 8 reasons why he thinks that the court was wrong in this case. I don't think I need to go into any depth on those. Also a great read. There, and finally, I'll just make a couple of top-line conclusions about the entire decision by the court today. It doesn't really settle much. In fact, hardly anything at all. It doesn't. I mean, the large fraction test is an afterthought. There is no math. Nobody cares. Apparently, even Justice Alito, who doesn't call the court to task on it like he did in Hellerstedt, I don't think there's anything left of the large fraction test, frankly, after today, except it's just another bit of verbiage that the court will use however it likes, depending on its perspective. Nobody knows really what the status of standing is. You've got 4 justices who insist that abortion providers have standing as a matter of routine. You've got 4 that say that at least they have to prove it, or 2 that say that they don't. And then you've got the Chief Justice in the middle. Arguably, you could say that he agreed with the plurality, so perhaps you've got a 5-4 court to grant standing routinely. But I think you've got enough for federal courts encountering abortion regulations to call for proof on the matter of the abortion providers' similar situation with the patients that they claim to represent in every instance. We'll see what that turns into going forward. Even in the question of admitting privileges laws, I mean, the court struck down Texas's House Bill 2 admitting privileges requirement. The Seventh Circuit privileges requirement out of Wisconsin fell by the wayside. Alabama folded its cards and went home. Louisiana did not. And all it got from the Supreme Court was a decision that this time, for these reasons in this state, admitted privileges are unconstitutional. So I'm not even sure that that particular very specific issue is settled. And then finally, stare decisis is more confusing and more divided, I think, than really it's been in modern history. There is a very sharp disagreement among the conservative justices over the meaning and mandate of stare decisis. It's going to find its way into further future abortion cases and into other areas of jurisprudence. I would say that the one thing that conceivably is a silver lining in this case is that you have 5 votes on the court. You've got the 4 dissenters, and you've got the Chief Justice who would insist that at least the proper standard in an abortion case is Planned Parenthood versus Casey, the undue burden standard, and with teeth. And the Chief Justice went through the result in Casey, and he said, look, Casey only struck down the spousal notice requirement. Everything else was good to go. And in this case, he just felt that there was too much of a burden. He couldn't disagree with the similarity in the language, the way the facts were applied, the district court's determinations about the impact ultimately on abortion in Louisiana.
Thank you for listening to this episode of SCOTUScast. SCOTUScast is a project of the Federalist Society, a not-for-profit educational organization of conservative and libertarian law students, law professors, and lawyers, founded upon the principles that the state exists to preserve freedom, that the separation of governmental powers is central to our Constitution, and that it is emphatically the province and duty of the judiciary to say what the law is, not what it should be. Don't forget to subscribe to our podcast series, including SCOTUScast and Practice Group podcasts, on iTunes or Google Play. For an archive of past podcasts, as well as audio and video of past Federalist Society events, please visit our website at fedsoc.org/multimedia. That's fedsoc.org/multimedia.
This has been a FedSoc audio production.